Good morning, everybody. This is Stuart Pardau here. I hope everybody is well. This is the MBA class, class 508 at CSUN. As we talked about the first class this past Tuesday, the 25th, we're going to have several remote classes here. So this is going to be one of them, and we're going to basically just pick up from where we left off this past Tuesday night, the 25th. We had a good introduction, obviously went through the syllabus, set through the expectations of the course, and began an introduction into sort of legal concepts, legal foundation. That's what I want to continue on right here on this video, and then we're going to roll right into very quickly agency and then the intentional tort section. So first, to cover continuation of the introductory principles. We had talked about distinctions between criminal law and civil law, the consequences that exist in terms of penalties for criminal law versus civil law penalties. The worst that can happen typically in a civil law case is you lose money. We also talked about this notion of equitable relief and various forms of equitable relief. Injunctive relief, which compels someone to stop doing something, and specific performance, which actually compels someone to do something. These are remedies, what we call remedies, that are not money damages. They are in addition to money damages. We gave some very specific examples about that. In the case of specific performance, the tree that was obstructing my view of the ocean, what would make me whole or make me completely back in the place I was and wanted to be. The real remedy for me might not be money damages, but simply removal of the tree. The act of cutting down the tree by the defendant in the case would be an act of specific performance or a prayer for relief of specific performance. By contrast, injunction is preventing somebody from doing something, making them stop doing it. And I think the example we used was an employee who is going to a competitor. If there's a senior executive at Pepsi-Cola who's moving to Coca-Cola, that individual may have proprietary information, maybe trade secret information of Pepsi that Coca-Cola may seek, and that Pepsi, for very obvious reasons, may not want to get into the hands of Coca-Cola. Again, Pepsi could sue for money damages, but the argument would be that would not be sufficient. That would be insufficient due to the fact that the real damages would be just letting that information get in the hands of Coke, and as a consequence, the only real remedy or the best remedy would be an injunction to prevent the employee from joining Coca-Cola. So again, a lot of things that could be utilized by plaintiffs. Just be aware there's money damages and there's equitable relief. Under the framework of money damages, there is compensatory damages. You're compensated for your losses, and we talked about what that might look like. Say, for example, in the case of a, heaven forbid, a car accident, right? You would suffer compensatory damages, maybe the damage to your property, in this case your vehicle, maybe personal damages that you suffered, the harm that you suffered, medical expenses, treatments, hospitalization, and possibly even lost wages. So that would be compensatory damages. But in the United States, and we've got a lot of folks from international students from different countries, we in the United States have a concept known as punitive damages. Punitive damages, and it comes from the word punish, or at least it's a derivation of that word. So the purpose of punitive damage, or at least one of the purposes, is punishment. The notion is if a defendant, and again, as we talked about, the person bringing the suit is the plaintiff, the person defending the suit, of course, is the defendant. If the plaintiff brings a suit, they can sue for punitive damages. Now, there's certain things that have to occur for that to happen, and you've got the Matthias case that you're supposed to be briefing, and we'll talk about this coming Tuesday, the 1st of September. But aside from that, punitive damages exist and may be brought by plaintiffs, and they're designed, if allowed, to punish the defendant for some very wrongful conduct. Typically, there's some sort of intentional tort that's required, some sort of reckless conduct, and some sort of wanton, that's W-A-N-T-O-N, wanton behavior on the part of the defendant, and the idea is the defendant's going to be punished. Not just punishment, however, there's also a component of deterrence. Deterrence, prevent somebody from doing it again. And who is that directed at? It's directed at that particular defendant, but it's directed against potentially all other defendants, because this is court proceedings or matters of public record. These were cases are reported on. They become known in the press and elsewhere. So the notion is that it becomes a message, a signal to the marketplace, so that other potential wrongdoers would then be deterred or self-police to not do. So it has a very effective element to it, and is a important element of a case if warranted. Again, you've got to show certain bad things, really bad things, intentional misconduct, wanton, reckless behavior, that sort of thing. And again, don't want to spend a lot of time of it here. You'll read about it in the Matthias case and elsewhere. There's also stuff around, consequential damages, which are damages which flow from the consequences of a particular damage or breach. So that would be if, in the example of the car accident, I talked about what those direct damages were: your property damage, your hospitalization, let's say, your lost wage. What would a consequential damage be? It's distinguishable. It would be those damages which flow from that situation. So, for example, suppose you get horribly depressed as a result of your injury. That may not be as directly related to the car accident, but it's a consequence of it. It flows from it. And say then you lose your job as a result because you can't really perform as well as you used to. Those could all be deemed to be consequential damages. So be aware that exists, but this is, introductory course. You guys aren't law students. Just to know that high level, it's out there. So again, roll back. You've got money damages. You've got equitable relief as a possible recourse. We talked, as I said, also about the distinction between criminal and civil. Most of the stuff in this class we're talking about civil, right? It's money damages. It's people seeking equitable relief. Corporations, partnerships, LLCs, contracts. I mean, these are sort of bread and butter, garden variety type of matters that commercial lawyers face, and people, when they do go to court, they sue for money damages or, as we talked about, equitable relief. Nonetheless, there are circumstances, and in this course we will identify those situations where criminal liability could also arise. How could that be? It could arise in the context of securities laws violations when we get to the securities law section. It could arise in the context of certain conduct by corporations or by their officers or directors that could be deemed to be criminal in nature. So again, it's out there, and we will cover those instances when it occurs, but the vast majority of instances, as I said, it'll be civil law type situations. Now, what we didn't discuss on Tuesday night, the 25th, was that what are the standards by which you judge somebody in a criminal case versus a civil case? They're quite different, as you would expect and perhaps hope. If you're going to go to jail, right, the bar, the standard should be a much stricter standard, a much more careful standard than, say, in a civil suit, right? So how is that specifically enumerated or set out in American laws? It's done the following way. There's a standard of proof, or a standard of burden of proof that's required. To convict somebody in a criminal case, what is required is what's known as a standard known as beyond a reasonable doubt. Beyond a reasonable doubt. So it means to convict somebody in a criminal case, to put somebody away into jail, right? The court, the jury, needs to find and believe that that person, the defendant, is guilty beyond a reasonable doubt. It doesn't mean that there's no doubt. You can have doubts, yes, but you can't have any reasonable doubts. As a practical matter, what does that mean? It's a very, very subjective standard at some level. But think of it this way. Are you 100% sure, or do you have to be 100% sure that that person is guilty? No, you do not. You do not have to be 100% certain that person's guilty. Not required. Do you have to be more than, say, 50-50? Toss of a coin? Yes, absolutely. You have to be more than 50-50, and actually a lot more. So it's somewhere in between that range. Somewhere between flip of a coin, you're really not sure, it's 50-50, or absolute 100% certainty. Somewhere in that zone, closer to 100%. Want to call it 80%, 85%, but But the reality is 90%. The reality is what's 90% for you is going to be different maybe for me, right? We're just all different in the way we perceive things, the way we may hear things. But the bottom line is you can have a doubt, but it has to be beyond any reasonable doubt. A lot more than 50%, somewhere less than 100% certainty. That's a criminal case. High standard to meet. Civil cases is different. You have a couple standards. I just want to focus on one of them, which is known as preponderance of the evidence. Preponderance of the evidence. And it's just a hair, a fraction, a sliver over 50%. You can be on the fence and barely on the other side, just over 50%, 50.0001%. And you know what? In a civil case, that's enough. That's enough to reach a conclusion that you find for the plaintiff or for the defendant. So the evidence could be real close. The evidence could be very, very tight, and you're not sure, and you're kind of on the fence, but you're leaning in one direction. You think it's slightly more in that other person's favor, however so slight, that would be enough. So if you're a juror, if you're a judge, you have a much higher threshold to meet to convict somebody in a criminal case. Your standard is beyond a reasonable doubt. Civil case, much lower standard, preponderance of the evidence. Okay. We've got a lot of people from different parts of the world, which is wonderful. We have a lot of exciting discussions, I'm sure, this semester, and we're going to learn a lot from each other. We're here in the U.S. Our standard, or I should say our system, is different than all others. But it's part of, let's say, a family of a legal system. And that family is known as the common law system. The common law system. What is that? It originated in the United Kingdom, in England. And given the historical patterns and the history that's involved and the United Kingdom's spread of its colonies throughout the globe, in certain parts of the globe, those parts typically adopted the common law system. So, started in the United Kingdom, but guess what? Typically English-speaking countries, Canada, United States, New Zealand, Australia, India, Singapore, Hong Kong, South Africa, to a large degree, has a common law foundation or a common law system. Very different than what's known as the civil law system. And basically the rest of the world is civil law. So the continent of Europe, right? And when I say the continent, I'm excluding the United Kingdom. France, Germany, Italy, common law, or excuse me, civil law countries. Asia, Japan, China, civil law countries. Latin America, Mexico, Brazil, Argentina, civil law countries. It all kind of originated on the continent. Germany, France, to a large degree, and it kind of spread. The rest of the countries kind of have their own way of, incorporating their own customs, their own practices, their own traditions. But the foundations began, to a large degree, in those two places. The United Kingdom for common law, the continent of Europe specifically, France, Germany, Italy for civil law codes. So what are the differences? Because there are differences. Common law countries have a tradition for what we call judge-made law. And what do I mean by that? We have this wonderful casebook, right? We talked about how exciting it will be for you to read, right? So this casebook has these cases in them written by judges, appellate judges, right? We talked about the Court of Appeals, Supreme Courts, etc. These opinions form the foundation of what our laws are here. So it's kind of judges are asked to interpret what the law is. They write these opinions, and these opinions then become part of the law. What's that called? It's called case precedent. Case precedent, Precedent, or stare decisis, if you want to get fancy with Latin terms. That's stare, stare decisis, decissis. And that forms a body of law that evolve. So a judge who has a case before him or her that's, say, a breach of contract case, say it involves, and which we'll get to in a week or two, offer and acceptance, or just, just offer. What constitutes a valid offer? Well, judge will look at the laws, write his or her opinion. That then becomes part of the case law, becomes part of a precedent, unless it's overturned, right? Because higher courts can overturn the lower courts. But the bottom line is, over a period of time, and imagine, beginning in England, back many centuries ago, 15th, 16th, 17th centuries, if some of you go to U.S. law schools, you'll be reading some of these old English cases, particularly in the areas of maybe property law or contract law. It can go back to the 19th century, sometimes even earlier, the 18th century, particularly for some of these old property cases. So it forms a foundation, and it's built on that foundation. And over time, it forms this case precedent. So that's an important part of the common law tradition. Not the only part, but the case law is a huge element of it. By contrast, civil law countries have what are known as codes, C-O-D-E-S, and they're interpreted very strictly, and they are written and very clear in what the expectation is, and judges are asked to just enforce what the code says. There's less of this notion of interpreting case law and having this body and foundation of cases. Another notable difference is civil law countries typically don't have the jury system. We talked a bit about the jury system in our class on Tuesday night. I'm not going to go over it further here, but that's another basic distinction. Okay, so what we call the common law, the case precedents, and by the way, this is also reflected in Chapter 1 of the Mallory book, so you can read about that there as well. So let's talk a little bit now about where all this stuff comes from. And by that I mean, what are the sources of law? Right? I mean, we talked about U.S. common law system. What are the sources of law? Well, an obvious one would be the one we just mentioned, cases, right? This judge-made law, that's case precedent, that's the stare decisis, that informs us as to what we can understand the law to actually be. And by the way, it's important that it's set up that way, right? Because judges then have an opportunity to refer back to what others did and base their opinions on that. Judges, and just to make very clear, judges cannot and should not, and the majority of times do not, just sort of invent things or make things up as they go along. They have to follow the case precedent. So that means you look back to what others did, and you're somewhat constrained, actually, and quite constrained by that precedent. But it's a dynamic system. It does move slowly. Change does typically occur slowly in the legal system. But that case precedent forms an element of continuity and consistency, which is important. But that's not the only source in a common law system. In a common law system, there are other sources of law. So when you see and you read these opinions, you'll see the judges going back and citing other cases, i.e. case precedent, stare decisis, for their reasoning, for their opinions, for their determinations. But they're not only citing cases. They're not only going back and going to the case precedent. What else are they doing? What else are they citing? They're citing what's known as something that's known as statutes. What's a statute? It's a law. It's a law that's passed by an act of the legislature, written into law by the executive. So we talked about federalism on Tuesday night. You've got the 50 states and the District of Columbia, but you've also got, which have their own specific systems, but you've also got the federal system. So the court system, for example, which is the judicial branch, the executive branch, which at the federal level, of course, is the president, at the state levels is the various governors, and the legislative branch, which is at the federal level, the House of Representatives and the United States Senate, both of which forms the United States Congress. That same legislative body concept exists at the various state levels. They typically have a higher body or an upper body known as the Senate. Typically in California it is known as the California State Senate, and a lower body which functions like the United States Congress, House of Representatives, which here in California is known as the Assembly. but states use different names depending on what state you're in. California uses that designation. But the point is here, the legislature, be it a state law, and we're going to cover a lot of state law here, right? Partnerships, corporations, LLCs, that's all going to be state law. Federal laws we talked about will be more securities laws, and the employment law that we cover will be a lot of federal law. So regardless of which system you're in our federal system, whether you're in the state system or the U.S. government federal system, it's the legislature which puts together, which passes the statutes, and the president, if it's the executive branch at the federal level or the governor at the state level, signs them into law. That then becomes part of a source of law, right? Because it's a law. So judges, this is the analogy I'd like to use. Think of it as a toolbox, right? Judges have a toolbox. They've got various tools they can use. One big tool they can use when writing their opinion, of course, is case precedent, stare decisis. What's another tool? Another tool is statutes, right? They pass a law. Congress passes a law, okay? The Affordable Health Care Act in the United States, right? Very famous law that was passed a few years ago. That's a statute, becomes part of the sources of law that judges will interpret, right? Statutes are very lengthy, or can be, and requires a lot of statutory interpretation. That is an important part of not only as a source of law, but in terms of our understanding and interpretation of these cases. So that's one source, case precedent. The supreme source, the highest source of law in the United States, of course, is the United States Constitution. And I probably should have mentioned that first. But that is the highest source. It is the supreme source. Now, constitutions are a relatively short document. Not every issue that we're going to be covering, not even close in this class, will touch or concern a constitutional issue. So, it may apply, more likely than not, will not apply for our purposes, but it's a source of law. And you always want to ask in a case, is there a constitutional issue here? If so, let's go to the Constitution. Let's see what it says and speaks to on this particular point. Again, to confuse you even further, particularly you international students, each of the various states also have their own constitution. California has a constitution. In our federal system, however, remember, one will take precedent over the other. Which one is supreme to the other? Federal is always going to, use a popular word today, trump the state constitutions. Okay? Federal law, and that goes for any sort of, if there's a statute, right? The states can pass their own statutes, their governors can sign them into law. If that statute at the state level is in conflict with the federal one, guess which one is going to, again to use a popular word, trump the other? The federal one will always be supreme over it. So if there's a conflict, federal always controls. So statutes, treaties. Okay, treaties are another source of law. What is a treaty? It's essentially an agreement between two countries, or two or more countries. What's a very famous treaty in recent years? Well, not that recent anymore. NAFTA, the North American Free Trade Agreement. That's a treaty, a trilateral treaty, not a bilateral, meaning between two, but trilateral. Between who? Between Canada, the U.S., and Mexico. It's a trade treaty, very significant treaty, which facilitated the opening of a lot of commerce between those three nations here that comprise North America. That has to be, of course, signed and approved by Congress as well, and is an important source of law. Not going to be that relevant for what we're going to be discussing here as a commercial law class, but nonetheless, you should be aware of it. What's another source of law? Another source of law is what we call a regulation. A regulation. What's a regulation? Regulation is something promulgated or put out by a government agency. It could be a federal government agency or state government agency. For our purposes, let's talk about federal government agencies. You've probably heard of certain agencies at the federal level, right? We all have, right? And we'll cover them some in this class. The Securities and Exchange Commission, the SEC, the Federal Trade Commission, known as the FTC, the FDA, Food and Drug Administration, that regulates the issuance and sale and marketing of drugs and food. These agencies were established at various periods in United States history. How did they come into being? They just didn't arise out of the ground from nowhere. They were created by acts of Congress. They were actually part of a statute. Congress decided to pass a law. We'll learn, and it's good to maybe introduce the notion here, the 33 Act, the 33 Securities Act, and the 34 Act. These were passed in 1933 and 1934, respectively, by the United States Congress, signed into law by the President. As part of that, Congress also created the Securities and Exchange Commission. It was part of the statute that this would be created. The notion here is Congress, the legislative branch, doesn't have the expertise, the ability, or frankly probably even the interest in policing every single action and activity of securities transactions. But the decision was made by Congress and signed into law by the President in the early 1930s. Again, remember the time frame here, what happened during that time in history, 1929, the major market crash, the Great Depression. Lots of people lost their lives and their livelihoods and all their savings and so forth in the stock market crashed during that period. And there was not a lot of regulation before that time. So the idea was, okay, Congress needs to respond to the will or belief of the American people. We need to pass a law that says greater regulation of securities. And we'll learn all about that when we get to the securities law section. But as part of that, we also need to create this agency called the SEC, because we, Congress, the President, the courts certainly, are not in a position to regulate on a daily basis all these laws we just passed. We're not in a position to do that. So we need to create an agency to do that for us, and us being the American people. So that agency has been in existence since the early 1930s. Same concept for the FDA. Okay, the Food and Drug Administration was created by an act of Congress. The FDA has been in existence for, I think, 100 years, maybe even more. These agencies then have tremendous power, obviously, because they're regulating these specific industries and these specific activities. And it's been duplicated across many, many areas, not just the three I mentioned. So the question then is, these agencies then themselves can actually put out regulations which have the full force and effect of a law. So think of each of these agencies almost as mini legislative making bodies with some very, very different attributes. Most notably is members of Congress, members of the state legislature are actually subject to elections. People who put out the regulations are government agencies. They're not subject to any elections. They're there and will continue to be there so long as they're funded by Congress. But they can put out regulations, and they not only can, they do, and put out a lot of them. Now, there's some unique elements to it. In the vast majority of instances, they have to put out the regulations in draft form, solicit feedback or comments from the general public, including you or me. You could open what's known as the Federal Register. They publish, I don't know if it's daily, but pretty regularly, massive amounts of information, massive what they call proposed regs, and solicitation of comments. And you as a citizen, or even I think even as a non-citizen, can submit your feedback and your comments. Typically, it's done by the industries that are being regulated because they have a real distinct interest in what's going on for obvious reasons, or the lawyers or lobbyists that represent them and so on. But the bottom line is there at least is some check and balance. It's not just the agency shoving down their ideas, although that can happen from time to time too. So regulations are a big part of a source of law because they become part of the things that judges will look at if indeed there is a case before them that's related to it. And particularly when we get to the securities law section, you'll see various regulations that are covered and often analyzed in some of these cases because they're part of the situation there. So we've talked about statutes, we've talked about the U.S. Constitution, we've talked about treaties, we've talked about regulations, we've talked about case precedents, stare decisis. What else is there? Frankly, not much. But there is one or two others I'd like to talk about. There's something called restatements, or just call them authoritative legal compendiums, okay? There's something that's known as the restatement on contracts or the restatement on torts. And these are massive volumes of books and materials written on one subject. Contracts on one subject, agency on one subject, torts. And basically everything you ever wanted to possibly have analyzed or know about it is there. And it's written not just by one person, but by a group of renowned scholars and other practitioners in the area. And they put together and they keep current and update these restatements. That can be a source of law too. Not a primary source, meaning you're not going to want to rest your whole case on that. The real meat is going to be the case precedent, the statutes, the U.S. Constitution, of course, if that applies, regulations, etc. But you might be able to weave in if there's some distinct points, very subtle points, because it goes into excruciating detail in all the areas you possibly wanted to know of, say, contracts or torts. And it may have something that's really on point for you. So that can be cited as an authoritative source of law and be included in the analysis of a judge, say, in a case, or by a lawyer when briefing the cases. Because we use the phrase brief, right? You submit the briefs to the professor. The briefing is a common term used in the U.S. for the documents that the lawyers submit to the courts, to the judges, when they're advocating. When those lawyers are advocating for their clients, the arguments they're making, the theories that they have to support their cases, what we call the briefings. Okay, the last source, which is kind of related to the restatement, is sometimes you see law review articles. What's a law review article? It's basically just a scholarly article in a publication that is written by, could be an attorney, a practitioner, often is a law professor, sometimes actually law students. Often law students write what are known as notes in the law reviews, and those are and can be cited by courts if stuff is in there that is relevant. So that's another source of law. Okay, so that pretty much covers sources of law. We talked about civil versus criminal and the standards behind it. Very briefly, the book mentions on page 9, substantive versus procedural. The only thing you really need to know there is, what's substantive. It's really much what we're covering here, because it's not a class on procedure, but you need to understand some of these procedural issues when you're going to be briefing and reading the cases. So a word on that. And we talked about plaintiff versus defendant, appellant versus appellee, petitioner versus respondent. I'm not going to restate that here. But I will put out the notion that there's two other concepts to maybe highlight. One is when you see the word summary judgment, right? What does that mean? Because you're going to see that sometimes. Or, let's just talk about summary judgment. It's basically a ruling by a court at the trial level, okay? Not at the appellate level, but at the trial level, before the trial actually takes place, right? Because you have all the series of the case. You file a suit, there's certain things that happen. Big part of the case is what's known as discovery, where both parties are required to exchange information. There's interviews that are called depositions. There's documents submitted called interrogatories, which solicit information back from the other party in written form. But after a lot of that, or at least when that process is occurring, one of the parties can file what's known as a summary judgment motion. Again, before trial, before the case goes to the jury, before the witnesses are heard in the courtroom, one of the parties can file what's known as a summary judgment motion. And that's a motion to the court, a remedy, well, not really a remedy, a motion to the court seeking essentially a statement by the court saying, you know what, there's really no issue here. There's no real genuine issue of material fact. As a matter of law, I win, and there's really no facts here which the plaintiff has brought or the defendant brings it as a basis to continue. So you'll sometimes see the reference to summary judgment. That just means one of the parties tried to file that motion or did file that motion saying, let's rule on this case, let's end this case before it goes to trial. And they either prevailed or they didn't. And the cases should inform you of that. The other thing you'll sometimes see is, or often see is, when the appellate case, and we're largely reading appellate cases, appellate court cases, Supreme Court cases, appeals court cases. You're going to largely sometimes see at the end, either affirmed, it just means they agreed with what the lower court said. Sometimes you'll say affirmed in part or reversed in part. So there are certain elements of it that they agreed to and affirmed, and other elements that they said, no, this was wrong, we're reversing it. And then you'll see sometimes a phrase called remand, R-E-M-A-N-D. That just is saying, you go back to the trial court and you retry it with this direction. Trial court, you messed up in these areas or all these areas. You have to, the case is not only being reversed, it's being remanded or sent back to the trial court to retry. Obviously with a new jury, and I guess oftentimes with a new judge, though I'm not entirely sure about that. Okay, so that largely covers sources of law. The legal system is outlined in chapters 1 and 2. Let's talk, although a little bit, since we're here, chapter 2, the resolution of private disputes. I did want to talk a bit about that. And this does go into, the jurisdictional questions. It does talk about discovery. It talks about how to file suits. We talked a bit about this already before, on Tuesday, about the trial courts and the appellate courts. I won't go over that here. Read the stuff on in personam jurisdiction, or also known or in rem jurisdiction. I'm not going to really test you on that, but please, have a general idea that you've got to have personal jurisdiction over that person. Venue basically just means where the case is being heard, so that's obviously an important consideration. It talks about the district courts. In the case of federal cases, I think the question came up, how do you know if it's a state law question or a federal question? Well, or federal case, basically, for our purposes, as I said, corporations, partnerships, LLCs, largely, if not exclusively, state law issues. By contrast, securities law and this course employment law will largely be federal law. Now, that is important to also put out that in the federal law system, when a federal law case, you have to have what's known as a federal question, or you have to have what's known as diversity of citizenship between the parties. I'm not going to test you on the diversity of citizenship issue. It's not a procedure, not a civil procedure class. You guys aren't law students, but just be introduced to the basic concept that in a federal case, you have to either have the federal question or diversity of citizenship. Federal question is just going to be a federal law matter. We talked about, I think, on Tuesday night, patent law, copyright law. Certainly for our purposes, what we're going to be studying in securities law, those securities law questions, the 33 Act or 34 Act issue, these are all federal questions. These are all federal law. So that could place you foursquare in federal court. If you don't have a federal question, but you still want to be in federal court, you have to have what's known as diversity of citizenship, meaning the two parties cannot be in the same state. They've got to be in different states. The amount in issue and controversy has to, I believe, be in excess of $75,000 or in excess. There's a bit of discussion here on the courts, which is good review. Particularly, take a look at Figure 1. There are, as we talked about, 11 circuits plus the D.C. Circuit. That's 12, and then the Federal Circuit, so 13. But we're in the Ninth Circuit, which is by far the largest circuit. As you can see, a lot of different states here that comprise the Ninth Circuit. So to take a look at Figure 1, page 36, it's good. It's good context and good background. Page 38 through 39 talks about some basic civil procedures. You should read that. You initiate a lawsuit by serving the summons. You have what's known as a complaint that's filed. The other party has to file what's known as an answer. Then the person who filed the original complaint can then reply to the answer. Then you go to the stage of maybe there's nothing here, so you file what's known as a motion to dismiss, which is kind of similar to, in general terms for our purposes, to a summary judgment in that it kicks the case out early. But the motion to dismiss is a distinct motion from a motion of summary judgment. It comes much earlier in the pleadings phase. Then you go to discovery, and that's really a major component of United States litigation where both parties exchange information, and that information exchange, as I said, includes stuff like these interviews, which are depositions. And just to give you a sense, a deposition is an adversarial proceeding. And it's stated under a penalty of perjury. You've got to state, it's like being in a court, though you're typically not doing a deposition in a court. Depositions can be recorded like what we're doing now, meaning video recorded, but they can also not be video recorded. But you would always have a stenographer, somebody taking the exact notes of what everybody is saying. So there's always going to be a transcript associated with a deposition, and increasingly also that person will be videotaped as well. And the lawyers are the ones asking the various witnesses questions. And you don't have to be a party to a litigation to be deposed. I've done depositions myself. I've been deposed, and I've, without being a party to the suit. So oftentimes witnesses are the ones being deposed as well, not just the parties to the lawsuit. So the rest of the summary here on page 43, 44, 45 is quite good. I urge you to look at it. One other thing to mention on page 46 about class actions. There's a lot of that in the United States, also in some of the other common law countries. I'm not as familiar with the civil law countries. I know Australia has active class action environment, but in the United States, class actions are just when a suit is aggregated among not just one plaintiff, but many thousands or tens of thousands or hundreds of thousands or more who bring a suit, and usually have one sort of named plaintiff, and then you're part of what's known as a class. So for example, and I'm just not to pick on airlines, but say airlines, and I'm making this up, were to be found to be overcharging one particular airline, let's say airline A, were to be found to be wrongfully overcharging certain legs of their flight, or certain, say they're LA to New York flight for whatever reason, and during a period of time, say January 1 through June 30th of 2015. Anybody who ever flew with that airline on airline A during that period could be part of the class. They can elect to opt out of the class. They don't have to be part of the class. They can bring their own lawsuit if they wish. But once they make the decision, or the decision I should say not to opt out, they're then part of the class, and you get these huge recoveries. The individual plaintiffs typically don't get a lot out of it. The lawyers who represent them typically do quite well, thank you. But largely it's relatively small amounts that are given to each, but the idea is over many tens of thousands or hundreds of thousands of people, it's quite significant. Let's talk finally a little bit about alternative dispute resolution. There is a major, well, just a fact now, but it's been sort of a trend for 20 years or more of what's known as alternative dispute resolution. Again, this is an important thing to put out, and I think one of you came up to me during the break and asked me to mention this in class, so I'm mentioning it here. Alternative dispute resolution is, to a large degree, a function of a few different phenomena. One is a belief that our court system is overburdened, right? I mean, everybody, again, we have a lot of people from countries outside the U.S. understand, or have a perception perhaps, that the U.S. country is a very litigious, meaning litigation-oriented society. And that's, I think, a fair and correct assessment. So one of the outgrowths of that is that our court system is perceived, or actually is, overburdened, and cannot sort of support all the disputes, all the problems, all litigation. So what's emerged is this almost private court system, let's call it. And what does that look like? What is that? Well, it's called alternative dispute resolution, or ADR for short. And it's got a couple of elements to it. It's voluntary. No one can really be compelled to do it. I mean, contractually, oftentimes consumers are now bound by these sort of one-sided agreements, and we really don't necessarily agree to it, but by using the service, you'd argue we agree to it. But the bottom line is, if I want to bring a lawsuit, unless the parties agree to it beforehand, I can always go to court. So unless I agree to it beforehand, entering into this alternative dispute resolution is really kind of a voluntary thing and a thing that we just decide, the parties decide to do to see if they can resolve the dispute through that mechanism. So there are a couple of elements, right? One element of alternative dispute resolution is you just try to sit down and figure it out, right? Sit down in good faith with the other party, whether with a lawyer, without a lawyer. Hey, can we just fix our problem? Can we just resolve this? That can work. Typically it doesn't because, you would have done that anyway, right? You would have never been in the dispute to begin with if you could work it out. But sometimes it's just, helpful to kind of just take a deep breath, step back and say, hey, let's sit down and see if we can really professionally get this done. Usually what's required, though, is the assistance of some professionals. Who are those professionals? Well, you'd often have to hire a lawyer, but maybe that lawyer would suggest, okay, instead of filing a lawsuit, let's see if we can mediate this case. Let's see if we can go to mediation, mediation. What is mediation? Totally voluntary and non-binding, meaning the findings of the mediation, both parties can agree to say, you know what, forget it, I'm not going to proceed with this thing. I'm not interested. But what do? You present your case to someone who's a professional mediator. That person hears the case. There's some evidence, some basic evidence is presented. Usually there's not any depositions or witnesses or anything of that sort, or any meaningful or any discovery for that matter. But sometimes the parties will submit some briefs with schedules and information and exhibits and that sort of thing, and try to really make their case to the mediator. And they submit the briefs, and then they actually meet with a mediator. But the mediator's job is really to try to get these parties together, to hear both parties out, hear what their views are, and make some recommendations, maybe push one party in another direction, push another party in another direction, and see, by virtue of just sort of airing these disputes out in a more kind of structured, formal manner, the idea is, well, maybe you can settle the case. But at the end of the day, both parties have to voluntarily agree to settle it on those whatever terms that are suggested or ultimately agreed upon. Other than mediation, what else is there? There's something called arbitration. Arbitration is binding, typically, almost always, and it really is kind of, think of it like a court proceeding, but without the judge and without the jury. It's a court proceeding with an arbitrator, sometimes one, sometimes three. Think of it, you probably couldn't have two, right? Because if both of them disagreed, you'd be back right where you started. So typically you just want one, but in more complex cases you may really need three. The challenge with that, though, is it can get extremely expensive. And mediation can too, though mediations usually don't take quite that long, usually a day or a couple days. Arbitrations can go on for many months because, again, it's like a court proceeding, except it's private. It's not in a court. It's not in a court chambers. It's in the arbitrator's office. The arbitrator receives, there's oftentimes, there will be evidence, there's depositions, there's interrogatories, there's discovery, some other limited discovery, there's briefings, and there's a bunch of hearings. So again, think of it as a private judge, and this can get very expensive. But the final, ultimate hearing or ruling of the arbitrator would be deemed to be binding, and unless there's some sort of egregious, horrible conduct, non-appealable. So arbitration can be deemed as another mechanism, and is certainly a major part of alternative dispute resolution. So the question is, why would anyone arbitrate? What's the advantage or disadvantage? First, some advantage, or at least some perceived advantages. Arbitration is often perceived as a more rational process. You read about, and we've all read about, right, sometimes these, quote, crazy damage awards. The McDonald's case that we talked about briefly, punitive damages case with a hot coffee. How could that possibly be? It's just, these juries are crazy. How can they give these massive awards? Typically, arbitrators aren't going to do that, right? Because they're experts in the field. They're retired judges. They're well-known lawyers or sometimes law professors. They're not going to do that, right? They're going to have a more reasoned decision. That's one perceived advantage. The other perceived advantage is, which by the way isn't always a correct perception, is that it'll be cheaper. and perhaps faster. Not always the case. I mean, the federal court system has gone on more of what's known as a fast track. It's usually, pretty good now, at least in some parts of the country, this part of the country, pretty fast in hearing cases and getting them through the system. And of course, once you file with the court system, you're not paying the judge by the hour. The judge is a civil servant. The judge is paid by the taxpayer. That's not the case with the arbitrator. You're paying that, and these arbitrators are quite expensive, or can be. At the low end, maybe $400. At the high end, $1,000 or more per hour. So they're not just charging you for when they're hearing the case, right? They're charging you from the very beginning, from the initiation of the suit, right, where you get that complaint, where you review the response to that complaint or the answer, where you review the motions, you review the briefings, you do it all. So it can be very, very expensive, potentially, particularly if you have three, right? Because that cost per hour is now multiplied times 3. So you guys get it. It can be a very valuable method sometimes, but other times, it could not necessarily be deemed to be advantageous. We're back. That is the end of the sort of the legal principles introduction piece. I want to talk just very little bit about agency, and that's chapters 35 and 36. Those are much shorter chapters, but let's just talk a bit about it. What is agency? Well, and I'll send you some materials under separate cover. I'll have that emailed to you or available on Moodle. But there's this notion of a principal and an agent. Principal and an agent. And that relationship between those two, between that principal and agency, is what forms the foundation of agency or agency law. And it's important for us because it's going to come up, and we're going to cover it throughout the semester as it comes up, in contracts, in torts, in employment, where the relationship is going to be quite significant. So think of it this way. You have this entity or this enterprise, which we'll call a principal. The agent is just acting on behalf of that principal. Think of the agent as an appendage or an arm of that principle. So in the legal context or in the legal framework, let's take an example of a corporation. The corporation you could think of as the principal, and its employees are the agents of the corporation, the agents who act on behalf of the corporation. So that creates or can create a principal agency relationship. And for our purposes, what's relevant about that is that ordinarily, because that agent is an appendage or part of that principle, the actions of the agent are going to be holding the principal will be held liable for those acts, because the conduct of the agent is going to basically be the same as or synonymous with what the principal is doing. It's as if the principal did it itself or himself or herself. The agent's acts are going to flow back to the principal. Why? Because the agent is basically in existence or working on behalf of and for the benefit of the principal. So naturally, if all those benefits flow to the principal, the idea is when anything incorrect or bad happens, provided the agent is actually acting on behalf of the principal or acting within the scope of its duties that are enumerated, then the principal is going to be deemed to be liable or will be held liable. So, as the book points out, and we'll get into what fiduciary relationships are, but and let's talk about it because we really haven't so far. What is a fiduciary? And the agent is going to be deemed to be a fiduciary of the principal. What is a fiduciary relationship? A fiduciary relationship is the highest level of responsibility that someone can have to another party, highest under the law. Ordinarily, right, and we're going to get to this when we get to negligence, we have a duty or an obligation to act as an ordinarily prudent person meeting a reasonable standard of care. If we fall below that standard, we're negligent. A fiduciary duty is higher than that because under an ordinary standard, what we're saying for negligence, for most things, you've got to act reasonably. You've got to act like a reasonable person. If you fail, if you fall beneath that, it's a problem. Fiduciary is up here. So, do I have a fiduciary duty to the person I'm just walking by on the street? No, I don't. But I do have an obligation to act reasonably, to act like an ordinarily prudent, reasonable individual. So what are those circumstances when a fiduciary duty is established? When does that occur? Well, special types of situations. One such situation is here in principal agency. Another situation, as we'll learn, is in the context of corporations. Officers, directors are fiduciaries of the corporation. They have a higher obligation. They just can't say, well, all I have to do is not be negligent. No, you have a higher standard of care than that. You have extra responsibilities. So officers, directors to corporations are fiduciaries. Partners, when we get to partnership, partners are fiduciaries to one another. There are other situations where fiduciary relationships are also established. A lawyer is going to be a fiduciary to his or her client. There are different types of authority, which I don't want to necessarily get into right now in any detail, but just do take a look at them on page 918 and 919. Introducing the concepts of actual authority, apparent authority, express authority, and implied authority. These are different types of authorities. You know what, I'll just briefly try to explain them now, but we'll continually go over these through the semester. As I said, I'll send you some other materials via email or on Moodle, separate cover. But, actual authority, apparent authority is how others may perceive the authority and that relationship between the principal and the agent. Express authority is how that relationship is actually clearly spelled out somewhere. Could be in a policy, could be in a statement somewhere, but it's expressly stated. That would be express authority. That's the clearest one, or one of the clearest methods of authority that we would see. It could be written in a policy, in a handbook somewhere. If you're an officer of a company, it'll specifically give you what authority you can do, how much you can purchase for the company. It'll tell you in clear language somewhere. Implied would be what's kind of understood to be the case, even though if it's not written anywhere. So even though it may not be written in a policy, it's kind of understood, hey, you're the CEO of a company, your authority to enter into certain types of transaction is kind of understood or implied by the nature of your job duties. So express, written down, implied, it's kind of understood from the circumstances. First one I mentioned, which I didn't explain very well, or at least not yet, is apparent authority. It's a third sort of element, which is how third parties may perceive that relationship. Do they legitimately believe that you're acting on their behalf based on your conduct? Again, it's kind of a difficult concept. I don't want to get into any more detail into it here. We'll get into a lot more detail later, but that's the general concept. Take a look at 918, 919. The rest gives you some more information about other duties. We talked about the fiduciary duty. There's also a duty of loyalty. You can't have a conflict of interest. You have to keep stuff confidential, and other important duties which are enumerated in Chapter 35. Chapter 36 then goes into the different types of authorities that we talked about, and all that. There's this notion of tort liability. Let's talk a little bit about that since we're going to be entering the tort section now. So page 944, tort liability of the principal. There is this notion of respondeat superior. That's on page 944 and 945. This is kind of what I referred to briefly in, within the scope issues, right? Because the principals will be liable for the acts of the agent under agency law, but there's one important proviso or one important qualification. The agent actually has to be acting within the scope of their duties, right? Think about it. If you're an employer, your employees, as if the corporation, say it's a corporation, did the act itself, right? Because they're all agents of the corporation. They're acting on behalf of principal agency. That liability flows to the principal. But you've got to also say, this is where common sense has to kick in at some point, right? Because clearly not every act that person does is the corporation to be liable. If that employee, on their own time on a Sunday afternoon, heaven forbid, gets into a car accident, driving to visit their family members on something totally unrelated to business, how could that possibly result in their employer being sued, right? That doesn't make any sense. So that wouldn't apply because they're not acting within the scope of their employment. It's a day they're not working. It's on time and matters that have nothing to do with their business. But ordinarily, they would be if they're within the scope. Very different facts or very different outcome if the facts differ. If the facts were it's a weekday and they're traveling on the freeway from point A to point B on company business, clearly would be covered by respondeat superior and result in that employer liability for the torts committed by their agents. And again, that standard is enumerated very clearly on page 944, employees, and they must be acting within the scope of their employment. Also a little tip, and you guys probably don't need the tips, you're MBA students, but when the book, or any textbook, but particularly this book, when it italicizes things or puts them in bold, really understand those are the key terms or included among the key terms that you should really be focusing on if they're part of the required readings. So take a look at 944, 945, and also 947, 948, and there's a pretty good summary outline of principles tort liability on page 948. So that's our very, very, very quick overview of agency, not our last, but some introduction. So please do the readings on chapter 35 and 36, and we will, as I said, I'll send some other materials to you via email or on Moodle about that. Okay, intentional torts. One of the assigned cases, or the assigned cases, the Matthias case, we'll be collecting those from you on Tuesday the 1st, and they're part of the assigned readings within this subsection. I will, as I said, hand out a model answer for you as well, and we'll go over those. Actually, I'm sorry, I misspoke. I will not be collecting them. I'm simply going to be going over them with you, but please do brief that case. So we talked about what a tort is on Tuesday night, the 25th. A tort's merely a civil wrong, distinguishable from what a wrong is in a criminal context. This is a civil wrong. There's no jail time possibility or other sort of such consequence. It's not a breach of contract. It's not two parties who have an agreement with each other, and then we're alleging or stating that person violated their obligations to me based on our contract. No, it's two individuals or groups of individuals who are harmed by the acts of another, harmed in some way. And there are different types of torts, a lot of different types of torts. But there's really two main categories. There's intentional torts, meaning the person who's what's known as the tortfeasor, T-O-R-T-F-E-A-S-O-R, tortfeasor, is someone who did a civil wrong, did a bad act, and did it intentionally. Intentionally. There's a whole category of intentional torts. Then there's a second category of torts that are not intentional, that really falls broadly under negligence. We're not going to cover negligence here. We're going to do that in class on Tuesday the 1st. Here we're going to talk about intentional torts. And again, negligence is essentially, and in some, the absence of acting in reasonable care. You're failing to exercise reasonable care. That is the fundamental cornerstone of negligence. In an intentional tort, you're actually doing something intentionally, hence the name intentional torts. Okay, the book on 178 talks a bit about punitive damages, compensatory damages. We've covered that already. The Mathias case goes into that detail as well, so we're going to hopefully be real experts in this subject matter by sometime on Tuesday night, the 1st. So page 181, interference with personal rights, battery. I'm just going to kind of now go through the various types of intentional torts. There are several of them, and I want to try to cover all of them here. Now, what's a battery? Again, I urge you to read this carefully, and for purposes, again, of our learning and also the examinations, you're going to need to know these legal principles. That's a requirement. There will be some, and is some, memorization in this regard. We'll have to figure out if we'll have open note tests or not, or limit the amount of open notes. I haven't decided what we're going to do there yet. Don't worry about it just now, but as you start to read and prepare, I want you to think in terms of, I've got to understand and know these principles. And there's no getting around some level of memorization of what each of these are, what the basic elements are. So what is a battery? It's real simple. It's the intent to cause harmful or offensive contact, or the intent to cause the apprehension of such contact. The basic concept, though, really comes down to this. Assault, battery, you often hear those two go together. The battery is really, think of it as some sort of offensive touching, okay? Or coming close to an offensive touching, a non-consented touching. It doesn't have to necessarily be punching somebody in the nose, though that would be an obvious one. But the idea is that you even can come into their space or their zone. That could be considered also a battery. So the bottom line is, though, it's some harmful or offensive contact. Some harmful or offensive contact. You can sometimes have batteries where there's a third person in the middle who's involved, who's like, you push somebody else, and I don't directly touch you. That third person does, but I'm the cause of that person touching you. I can still be held liable for a battery in that situation. Assault is when there's an attempt to offer that harmful, and there's some sort of apprehension. There's some sort of apprehension of harmful or offensive contact. So, think of it as a threatened battery, right? Whereas in battery, there's the harmful or offensive contact. In an assault, there's the apprehension or the fear that that's about to come. You're creating that fear. So those are two specific intentional torts and causes of action. And the book gives an example. Suppose that the defendant fires a rifle at the plaintiff from a great distance, misses him, and only later does that plaintiff learn of the attempt on his life. So you're walking in the woods, defendant shoots the bullet, you have no clue that that's been fired at that time. You only learn about it later. Does that constitute an assault? And the answer is probably not, because there's no apprehension. There's no immediate sense of immediate apprehension of, this is about to result in a battery. It came much later. Normally, are words, mere words, considered an assault? The answer is typically no, unless they're accompanied by surrounding circumstances or acts that indicate some intent to carry out that threat. Okay, what's another type of intentional tort? The intentional infliction of emotional distress. You're actually intentionally, and you should know that there's also a similar action under negligence. You've negligently inflicted some emotional distress on somebody. So you've really got emotional distress, and then you've got one tree, tree of emotional distress. One branch of the tree is intentional, another branch is negligence. Here we're in the negligent or intentional branch. Here you're just, intentionally trying to inflict harm on somebody so they become distressed emotionally, right? You know someone who is ill, and you go visit them in the hospital, and you do your best to make them feel really horrible when they're really down already, and you're intentionally trying to inflict harm on them by, saying bad things to them and, doing other acts. It has to be intentional or reckless. In other words, a lot of these intentional torts, you have to say, I want to actually do everything I can to harm this person. Yes, that's a clear instance of it, but it also can be if you're just reckless. If you if you have complete disregard for anything that's reasonable, and you're acting in a completely reckless manner, that too can result in liability for this intentional tort and others. So that is an example of intentional infliction of mental distress. There is a very interesting case here that's cited regarding Hustler magazine versus Falwell, which is a Hustler magazine, a pornographic magazine, and deals with one of the causes of action was intentional infliction of mental distress, and there were some cartoons in this that were very disparaging of the plaintiff in the case, Mr. Falwell, who was now deceased, was a famous religious figure, and he felt that it was defamatory of him, but also was designed to create distress, to inflict mental distress, or create intentional infliction of mental distress, and it was found to be not there. There's also some other cases cited here, Snyder v. Phelps, which is a good example as well. So please read that. You should know as well that and the point the book makes, of course, is that free speech is a key component. As I said, we don't have a lot of constitutional law issues here in this course, but here's an example where we can actually raise it, and that is what we call the First Amendment. First Amendment gives us what? The right to free speech. That is it's a supreme law of the land. It's a primary consideration, the primary consideration against all these others. So if I'm going to bring a case or a claim for intentional infliction of mental distress against the other party, there's an element of I'm really asking for a major remedy here, because we recognize the First Amendment, even offensive speech may be offensive to people, but it's still going to, in most cases, be protected under the First Amendment. So it's a very high hurdle, and these intentional infliction of mental distress cases are oftentimes difficult, I think is the point the book is making, difficult for courts to find in the plaintiff's favor, and therefore often fail as claims. False imprisonment. This is another intentional infliction of mental distress. People think of false imprisonment as, I'm just randomly picked off the street by the police or by the FBI and thrown in jail, and I'm imprisoned. That can be false imprisonment for sure. But here, remember, it's not a criminal context. We're talking about a civil wrong. So what does false imprisonment mean? You're basically being boxed in a confined area by a defendant, and you're not allowed to leave. You're essentially held prisoner. And there's some different facts that can come up, to this, and I don't want to get into all of them, but the bottom line is, you're confined to a certain space, and you're unable to get out. You don't have to necessarily be locked in, with a key that's thrown away, that no doors, no windows. It can be that, and it would be that, of course, but it can be more broadly interpreted than just that. It can be confined to a certain space, and maybe there's a very threatening-looking person on the outside, and even though you can see outside and you're seemingly free to leave, the message is that you can't, right? Even though if it's not clearly stated. Circumstances like that are the ones you might want to look for. That too could be deemed to be a false imprisonment. But the idea is you have no reasonable means. You're there without your consent. You have no reasonable means of an escape or no reasonable means to get out. Okay, other intentional torts. This ties in back to the free speech issues. Defamation. What is defamation? Think of defamation as two types: slander, libel. Slander, libel, both falling under defamation. Slander is spoken, libel is what's written. Defamation is basically the tort that can harm the interests of somebody's reputation. Okay? It's defined as something that's stated where there's no exception, no what we'll say is unprivileged. We'll get into what that means in a second. There's a publication, and publication, again, if it's libel, it's written. It means it will be written in a newspaper or on some website or something. But it doesn't necessarily have to be published in the form of a writing. It can be spoken, and that would be slander. And it has to be communicated to a third person, not just to the person you're speaking about. Third, it has to be false and defamatory. And four, the statements have to be concerning another. So 4 requirements. It's page 189. I already talked about the libel slander distinction. In terms of what constitutes a false or defamatory statement, truth is always going to be a complete defense to a defamation case. So, if somebody sues me for defamation, I can always respond by saying, and very possibly and likely prevail, if I can demonstrate, no, what I said is true. If I were to say that, Joe is a criminal, Joe has been convicted of a crime, Joe sues me for defamation, saying, how dare you call me a criminal? If I can produce evidence which suggests, indeed, Joe was convicted of a crime, and these are the years he served in jail, and these were the offenses, I'm completely free. I win my case. Why? Because it's the truth that Joe is a criminal. By contrast, if Joe is not a criminal, and I assert that he is, and I make these statements that he is, I have no privileges to say that, meaning there's not these exceptions. It's not true. There are other privileges, which would mean, for example, say there's certain people who have immunities from defamation. Members of Congress, when they're on the congressional floor talking about things, they can say basically whatever they want and are immune from defamation actions. So unless I have one of those privileges or one of those exceptions, or unless I can show that it's actually the truth, that meets the first one. If I've published it, meaning I've communicated it somewhere to other third parties, that meets that part of the test. And if it's actually false and defamatory and about that other person, it's very likely, therefore, that I would have some sort of liability for defamation. Now, the book points out that another important distinction between libel and slander, libel again being the written, slander being the spoken. Libel, because things are written, there's an element of permanency, right? When you say things, they just kind of are said and then they're gone. I mean, increasingly, that's not the case because everything's being recorded. In which case, it's really now more of a libel because there is that recordation. But historically, before the digital age, there's been this special seriousness and permanency that's been attached to the written word that we allow recovery for libel without proof of special damages, meaning without any actual proof of actual reputational harm or some other actual harm. You don't need to prove these special damages to bring a libel case. If you just show these 4 elements, it's not unprivileged, or actually it is not privileged, I should say. There's been a publication, it's false and defamatory, statements of a concerning or other. You can bring these libel cases without proof of special damages. And I'm reading now from 189. Slander, on the other hand, generally you do have to show these special damages, unless it's what's known as slander per se. And what's slander per se? It's a very narrow sort of set of circumstances. You've maybe slandered somebody about committing a crime involving moral turpitude or potential imprisonment. That's the one example I gave a moment ago. A loathsome disease. Gosh, what is that? Use your imagination, but think of some of the really sort of cruddy diseases you could possibly get that are associated maybe with certain types of behaviors or conduct. That might be falling within that. Professionally incompetent or guilty of professional misconduct. Again, this notion of a person's livelihood or ability to earn a livelihood is critical and fundamental. So if you start to slander somebody about that, about their business, about their professionalism, that could be deemed to be slander per se, or is guilty of some sort of sexual misconduct. So it's these kind of sort of fundamental, scandalous things can be considered slander per se, and therefore you don't have to demonstrate these special damages by virtue of just presenting slander per se gets you to that point. The false or defamatory statement, as I said, kind of speaks for itself, of or concerning the plaintiff. It has to be about that person. Humorous stuff, parody, if it's clear that it's humor or parody, sometimes it's hard, increasingly I think, at least in my opinion, harder sometimes to, where does that line begin and end? But historically, humor, satirical accounts, not going to be the basis for a defamation action. And then, the publication requirement, as we talked about. The defenses, as I said, truth is kind of the absolute defense, kind of the ultimate defense. If you can demonstrate, no, statements I made are not defamatory, they're actually true. Take a look at the various privileges, judicial proceedings, legislators, I should say, witnesses in the course of legislative proceedings, certain executive officials, et cetera. I'm reading at the top of 191, reflect these privileges or these exceptions that would insulate you from any claim of liability under defamation. With respect to public figures, that's going to be a higher standard. The average person, and you don't have to be famous to be a public figure. I mean, conceivably, a professor at a university can be considered a public figure in theory. You don't have to be the President of the United States to be deemed to be a public figure. But if you're just a private citizen, doesn't really have a public a profile in the traditional sense, you don't have a higher standard to bring if you're bringing a defamation case. By contrast, if say you are a famous actor and you're bringing a suit, you need to demonstrate malice. You need to demonstrate that additional requirements, some sort of reckless disregard for the truth that brings a higher level of proof that's required. So it's a much higher burden if you're a public figure. And the idea is, look, you're a public figure, you're out there, you should be able to take a lot of stuff. And the idea was, or is, if it did not have that additional higher standard, you'd have public figures bringing a lot more suits. Just think of all these tabloids, right, that could be sued left and right. And they often are actually still, despite this higher standard. But imagine how much more we would have if you didn't have this higher standard for public figures. Let's take a look at that at 196, 197, 199, and 200, and that's good help for you. Figure 1 at the top of 201 is a very good summary as well. So please do take a look at that, the constitutional aspects of defamation and the distinctions between official plaintiff, public versus private figure, and there's distinctions also, sub-distinctions of private, who may be the matters of public concern versus private concern. I'm not going to test you on those distinctions, more so just generally differences between public and private. Plaintiffs in the New York Times v. Sullivan standard under the public figures. Okay, invasion of privacy. This is an older tort. We have in the development of privacy law, which is important and distinct, and more recent. We have things like companies have privacy policies. There are in the United States various statutes, Gramm-Leach-Bliley, Title V, HIPAA, various laws that have been passed within various sectors of the economy, HIPAA for healthcare, financial services for Gramm-Leach-Bliley, which are designed to protect people's privacy within those areas. Separate and apart from that, there's a whole body of law that is in the common law that has existed for a lot longer period of time, which deals with, as a tort, what are known as invasions of privacy. That's what we start to talk about on page 201. There's this notion of intrusion on solitude or seclusion. Any intentional intrusion or on the solitude or seclusion of that other person constitutes an invasion of their privacy. I mean, if I go to my neighbor and get a drone to a mini drone to fly into their house, the size of a fly, and starts taking pictures of all their stuff and video recording all their activities, that would be very inappropriate, very wrong, of course, and would be a violation of a ton of laws. But one of the laws it would probably violate, almost certainly one of the claims that would be brought by that neighbor whose seclusion would be this very tortive, intrusion on their solitude or seclusion, right? This notion that we're individuals, we have these basic rights to be left alone. You cannot invade or intrude on those rights, and that would be a basis for such claim. Public disclosure of private facts. Again, these are torts, just to put it in some context, these are torts that have been around for a long, long time, since the beginning probably of the earlier century, the 20th century, and kind of arose and developed as a result of, at the time, the growth of a mass media, right? You always had newspapers in this country dating back to before the country was founded, but the ability of newspapers to be mass produced and distributed on a rapid level, really kind of took off earlier in the 20th century. And with it, the development of photography, the ability to take pictures of people, taking pictures maybe in their private moments and then distributing it in these mass-produced newspapers that were distributed, more rapidly and more quickly. The growth of the telegraph, all of this sort of thing, telephones, all around, early 20th century really started to mushroom, to take off. Not coincidentally, these torts grew with it. But remember, this is well before the digital age, well before the internet, well before social media, well before mobile devices, well before smartphones. So all of this stuff is just, magnified many, many times. These torts still exist. These claims can still be brought, but this area of the law is a little fragmented, different. There are all these new privacy laws, as I mentioned at the very beginning of this section, that have nothing to do with what we're covering here, but also relate at some level in the sense that they're designed to protect people's privacy rights. Technology continues to outstrip where the law is, and still much to be resolved. Public disclosure of private facts. This is about the publication of facts concerning somebody's private lives. That could also be deemed to be an invasion of their privacy. And the standard is the publicity going to be highly offensive to a reasonable person? Private facts are what they are, but the question really is, what is a private fact in this day and age? I mean, when you can go to Google and find out virtually everything about anyone, but this is still nonetheless a potential claim that is out there. False light publicity. This is where you try to put somebody in the public eye that and present them in a way that is false and misleading. I mean, this could be done notably with photographs, right? You could take a photograph of somebody that puts them in a situation where they appear to be something that they're not, maybe someone that they're not, or with somebody that they're not, maybe an embarrassing photograph with someone who appears to be maybe on a date with somebody of the same or the opposite sex, when in fact that was not what they were doing or their intention. And if you put that out there, it would give an impression, a false impression of something. That's what this is talking about. This is what this protects against and gives plaintiffs a right to bring an action against. Commercial appropriation of name or likeness. Okay, this is an important one, and quite relevant. This is one, you know, there was a recent case with Michael Jordan that maybe some of you saw, the former basketball player, the retired basketball player. Still very, very successful. I think he's a billionaire, actually. He has a lot of brand equity in the Jordan brand, in his name, in his likeness. And there was some proprietor, some store that tried to use his likeness in a way that he didn't consent to. He didn't agree to. He didn't even know about it until later. And he sued them and recovered, I believe, a substantial amount of money as recent matter. But it's not just famous people. You know, if any one of us, for example, had our photo with our name underneath it, say, too, but even just our photo at the local Italian restaurant, you know, I love the food, I love the pasta here. Well, you know, I may, in fact, love the pasta there. I may have even said that, but if I didn't consent to my name, my photo being used for that purpose, guess what? I have a claim. So anytime, if you're a company and you want to use somebody's likeness, you want to use somebody's photo, their name, whatever, to promote your product, your service, you got to get their consent. And it's got to be a clear, express consent. Otherwise, you run the risk of liability in this regard. Page 205, misuse of legal proceedings, something known as malicious prosecution. That's bringing a case that you know has no merit. You're just doing it to harm people, to make their lives miserable. You just can't do that. You're not allowed to do it, and it's an intentional tort. It's a wrongful use of civil proceedings. It's what's known as abuse of process. It's a tort, an intentional tort. Fraud is another. It's called here also deceit. Typically, just fraud, capital F. Fraud is a tort where you're making knowing misrepresentations. It's just a fancy way of saying you're lying. You lied about these things. It's not just some small little lie about some small little thing, but it's a big lie. You know, you're selling your car, and you know you knew and have known that there have been tons of problems with the carburetor. You know, the electrical stuff doesn't work well. Yet when you're selling the car, you specifically say, "Oh, it's a great car. And in fact, the carburetor runs smoothly. The electrical is awesome. This is the greatest car ever. Never had a problem." When, you know, in fact, it's the opposite. That's a clear misrepresentation. That's a clear basis for somebody bringing a fraud action. But it's not just so much about always what you say. It's also about what you don't say. It's about those facts that you may keep out, that you may omit, can also be the basis of a fraud action. So it's not just always what you say. It's sometimes what you leave out can also be a basis. Interference with property rights, and this is an important section. Trespass to land. This is where you're physically entering the plaintiff, as I'm now on page 206, you're physically entering the plaintiff's land or causing another to do so. So you can do that by chasing somebody else onto the land. Remaining on the land after your right to remain there has stopped. Failing to remove from the land anything that one has a duty to remove, or causing an object or other thing to enter the land, or invading the airspace above the land, or the subsurface beneath it. So, above, on, or below. So all of those can constitute those things. So take a look at that, page 206. That could be trespass. But bottom line is, you're entering somebody's property either, through some traditional means, meaning you're just walking across it, or staying there without being allowed, to stay there, without any rights to stay there, pushing somebody into it, forcing them, some other third party, to be in there. That could be the basis of a trespass. Flying above it, or crawling holes underneath it. That could be considered a trespass too. Private nuisance. That's some type of interference with the plaintiff's use and enjoyment of the land. So, trespass normally is some sort of tangible interference, whereas some sort of tangible invasion, whereas nuisance usually involves some other interferences. So, an odor, some sort of foul smell. You're interfering with other person's uses and enjoyment. You've opened a sewage treatment plant right next door to your neighbor because you hate their guts and you want to make their lives miserable. So you want the smell and the odor to constantly filter through, so to speak, their living room and their kitchen, right? Lovely. That could be deemed to be a nuisance. But it could be smoke as well. It could be noise, right? You could be, just a wild party animal playing your music, loud parties, all sorts of things going on till late at night. That could be clearly a nuisance as well. Conversion. What's a conversion? It's taking intentionally dominion or control over the plaintiff's personal property without their consent. In plain English, taking somebody's other property. Okay, I mean, it's taking something that's not yours, or interfering with it in such a way that it's effectively taking it. That's a conversion. Usually, the personal property in question is the plaintiff's goods. And page 209 talks a little bit more about that. Other examples of intentional tort liability, they're mentioned here on page 209. Read about those, and that's pretty much it. I'd like you to read, in particular, the cyber law in action. This is a very interesting case that we could just maybe talk at the beginning of class about. The Hamity case, cyber law in action. It's a real life case. Well, they're all real life, but this is very kind of funny in some level. It's a guy who's using a corporation's email address to deliver unsolicited emails to large numbers of people in the corporation. Just to give you an idea of how somebody can maybe, mess with a system. But it was one of the very earlier cases. The internet was already around by that point, or at least the public internet, for 10 years or so. But this is one of the first cases that we came across that was trying to apply some of the older concepts, in this case trespass, to the cyber world, and to cyber law. So read the cyber law in action, Hamity. It was a California Supreme Court case from 2003. And that's on page 2009 and 2010. So with that, I think we've covered a good section here. Just to recap, started out with the sources, or finishing up with the introduction, legal concepts, sources of law, laying the predicate for the rest of the class and the semester, then had a brief discussion of agency, and now had a good, solid recap discussion of intentional torts. We'll come to class, we'll cover the Mathias case. I do want to talk about Hamity, and then we'll go right into negligence. So I hope you're having a wonderful day or evening, wherever you may be, while you're watching this, and I'll see you in a few days. Thank you very much.